So what was it like in the 1970s in the Dallas-Fort Worth area? This is just some snippets for things that were going on. Police recorded the license plate numbers of cars at the first Texas Gay Conference in Fort Worth. They did the same thing at bars and nightclubs to populate their surveillance files. The Dallas Motion Picture Review Board established a new classification, P, for perversion for homosexual conduct. That was in 1976. In June of 1977, Anita Bryant, who is a spokesperson for the Florida orange industry, successfully led a referendum campaign in Miami-Dade County, Florida, that overturned a non-discrimination ordinance passed to protect LGBT. The repeal passed by 69.3% of the votes cast, so it was very lopsided. Dallas Independent School District Nolan Estes said he didn't think there were any gays or lesbians teaching in the Dallas schools, but if he found any, he would fire them. Well, it turned out that Mr. Estes ended up receiving a good education about this issue for himself. There are plenty of LGBT in the schools. 10 people dancing at the popular Village Station bar were taken off the dance floor, arrested by Dallas Vice Police, and charged with public lewdness. 2 pleaded guilty, the rest fought the charges. Uniformed police officers routinely entered gay bars, not in response to calls for assistance, but basically to intimidate patrons. On November 30, 1978, Harvey Milk, who was the first elected openly gay supervisor in San Francisco, and Mayor George Moscone were assassinated in San Francisco City Hall by fellow supervisor Dan White. Dan White was found not guilty on account of diminished capacity by using what reporters labeled as the Twinkie defense. As an aside, Harvey Milk had been in Dallas a few months earlier to speak at an educational conference co-sponsored by the Dallas Gay Political Caucus. Of course, you could be evicted from your apartment or fired from your job. My first law partner and his husband were both fired once their employers, a bank and a school, found out about their sexuality. The Metropolitan Community Church was active in Dallas, but besides the church, the Dallas Gay Political Caucus, and bars, there were very few LGBT organizations or social outlets. But it was the high day of disco. Had to find something positive there. Finally, AIDS had not been publicly identified as a health concern. Pervading virtually all of these activities and actions was the fact that LGBT were criminals 24/7 because of Section 2106 of the Texas Penal Code. What precisely did Section 2106 and related definitions say? Quote, a person commits an offense if he or she engages in sexual deviant intercourse with another person of the same sex. Deviant sexual intercourse means any contact between any part of the genitals of one person and the mouth or anus of another person. Violations were punishable by a fine of up to $200. The Dallas Gay Political Caucus was formed in 1976. It was renamed later, by the way, as the Dallas Gay and Lesbian Alliance. It had a small following. A typical monthly meeting consisted maybe of 20 to 30 people. But membership and activities expanded tremendously in 1977 with the Miami-Dade referendum threatening. The referendum was a catalyst that caused many to get involved, myself included. I attended the February meeting with Steve Wilkins. The church sanctuary was standing room only. Energy was electric. Steve stood up and nominated himself for a vacant board position. He was elected. Not long afterwards, Steve was elected president. I was elected to the board in the next meeting in March, as were Louise Young and Don Baker. Most all of us were in our late 20s or early 30s. At a planning retreat in the summer of 1977, the board identified as a top priority removing 2106 through legislation or litigation. There were three other goals. One was to pass a non-discrimination ordinance. The next was to educate the whole community about homosexuality. And the last one was to create a community center. It's amazing that all of those things have happened. The Baker versus Wade litigation. The Texas Human Rights Foundation was also formed in 1976, and its sole purpose was to mount a legal challenge to 2106. In 1978, the decision was made to make the organization a statewide one. The name was changed to the Texas Human Rights Foundation. Sometime after that, I received a telephone call from Mort Schwab, who is the president of THRF. He described their mission and decision to expand statewide with board members representing the other major cities. He invited me to take a position on the board, and I did. Mort also asked me to identify other Dallas area activists who would be willing to serve on the board and be actively involved, not just sit around and do nothing. I introduced him to my attorney friends Mike Anglin and Lee Taft. They were soon elected to the board. Board members were later added from Austin and San Antonio. The board formally decided in the summer of 1978 to initiate a federal lawsuit to challenge Section 2106. Mounting the lawsuit would be a massive undertaking. To be successful with the case, we needed an experienced federal trial attorney, an appealing and durable plaintiff, expert witnesses to educate the judge and public, increased public awareness, and with a more favorable opinion about our quest for equal rights. And last but certainly not least, we needed money for the attorney, for PR, and for operating expenses. As an aside, as to fundraising, it turned out there would be no mega events or mega donors. Events were tailored to meet local community needs. Outreach was made to small towns in East Texas, the Panhandle, San Antonio, South and Southeast Texas, in addition to the cities of Houston, Dallas, San Antonio, Austin, and Fort Worth. For some events, admission was charged in the amount of $21.06. In addition to getting 2106 declared unconstitutional, our objectives for the lawsuit were educating and empowering LGBT. We hoped that people would come out to their family and friends in response to publicity about the lawsuit, mobilizing and establishing contact among the various LGBT communities situated across the state, educating the community at large through articles in newspapers and magazines as well as at events. Finally, increasing opinion in favor of ending 2106. Over time, editorials appeared in newspapers in Dallas, Houston, Austin, San Antonio, and even San Angelo, Texas, calling for the repeal of 2106. Strategy for the case. Hiring an attorney was the first order of business. Several attorneys were contacted. Mike Anglin reached out to Don Mason, who was a Dallas trial attorney, who recommended Jim Barber. Jim was a tough federal law litigating attorney with experience in civil rights cases. Mike, Lee, and I met with Jim, who had prepared strategies for the case. We quickly decided that he would be a knowledgeable, no-nonsense attorney. We agreed on a compensation amount, and Jim was hired in September of 1978. The three of us continued to meet with Jim to discuss strategy as the case proceeded. I don't think any of us imagined at that time the case would drag on into 1986. The ideal plaintiff. Part of Jim's strategy was to find an ideal plaintiff. We would need someone who is open and willing to interact with the press and who is articulate and admired. Several of us on the THR board had worked with Don Baker and the DGPC. In fact, Don was one of my closest friends. Don was well aware of our plans for the case. Mike, Lee, and I decided quickly that Don would make an exceptionally powerful plaintiff. A Navy veteran, he was respectful and well-mannered. He was good in front of crowds. He would be willing to be interviewed and attend fundraising events, and he was sincere. Don had been a school teacher, even receiving one of the Teacher of the Year awards. He had a master's degree in education from SMU. He was an active member in his church, and he was also teachable about the legal issues. Despite knowing that he would lose his privacy and with the potential for violence lurking, Don agreed to be the plaintiff. As such, he agreed to disclose intimate details about his private life to intense personal scrutiny. This was no small sacrifice. With his decision, Don became one of only a handful of openly gay men in Texas. When Don testified in court, he described intimate details of his sex life. Don did all this with his parents seated in the courtroom. Expert witnesses. Selection of expert witnesses was handled by Mike working with Jim. Our experts were all degree professionals with outstanding credentials in their fields. They were also knowledgeable on the subject of homosexuality. Psychiatrist Judd Marmer was the former president of the American Psychiatric Association. William Simon was a sociologist who worked at the Alfred Kinsey Institute before moving to Texas to take a new job. Professor Victor Furnish taught at SMU's Perkins School of Theology with a focus on the New Testament. Filing the lawsuit and the trial. The decision had been made early on to proceed using federal law and not Texas law because of developing federal constitutional law about privacy reflected in several U.S. Supreme Court cases: Griswold versus Connecticut, Stanley versus Georgia, Eisenstadt versus Baird, Roe versus Wade, and yes, that's the one we don't know so well, and Carey versus Population Services. The lawsuit was filed November 19, 1979, and named the defendants as Henry Wade, District Attorney, Dallas District Attorney, and Lee Holt, Dallas City Attorney. The defendant class was later expanded to include all district, county, and city attorneys in Texas responsible for enforcing Section 2106. The trial was held before newly appointed federal judge Jerry Buckmeyer in June of 1921. It lasted 3 days. I was surprised that Judge Buckmeyer had his 13-year-old son in the courtroom as an observer every day. Those days were both emotional and an empowering event. They were also a little scary because people attending the trial might be assumed to be homosexual. I mean, why else would they be there? That presumption, especially for us attorneys, could result in loss of business or being fired immediately. The testimony and some of Judge Buckmeyer's findings of fact. About Don Baker, the judge noted that Don was a Boy Scout and a 4-year Navy veteran, honorably discharged. He was, quote, very sincere, very credible witness. 3 full pages of the opinion described Don's life and his agony in dealing with his repressed homosexual feelings. I had the deepest admiration for Don, testifying in open court and to the entire world about some of the most personal facets of his life. I do believe that Don's testimony may have had an impact on the judge because in footnote 52, Buckmeyer stated that, quote, from the testimony of the plaintiff Donald F. Baker about his life, about the reluctant, painful recognition of his homosexuality, his disgust and self-loathing and fear, his isolation and suffering, and the eventual reconciliation of his exclusive homosexuality with his devout religious beliefs and family values, it is, quite a sentence, it is evident that Don Baker's resulting decisions concerning his sexual needs and desires are of the most personal, intimate, and important concern, just as they are for heterosexuals. Concerning our expert witnesses, Drs. Marner and Simon, the judge said their qualifications as experts in the field of homosexuality are impeccable and their testimony very credible. two significant findings noted by the judge. Exclusive homosexuality is not chosen, but fixed at an early age. It is not a disease and would be difficult and painful, if not impossible, to change. Also, the existence of the law results in stigma, emotional distress, and can cause severe mental health problems. Excuse me. Psychiatrists, the defense witness, the primary witness for the state was psychiatrist James Grigson, who stated that having 2106 benefited the health of minors and homosexuals. For minors, the law reinforced cultural norms and the superego. For heterosexuals, the law would encourage them to seek psychiatric treatment to be cured. Judge Buckmeyer's comment on this latter point, this is, quote, not only preposterous, but contrary to the facts. As to Judge Buckmeyer's overall judgment about Grigson's testimony, quote, this court completely discounts Dr. Grigson's testimony and opinions. His opinions are flawed, inconsistent, and directly contrary to the plaintiff's experts. Finally, defendants Henry Wade and Mr. Holt submitted depositions. As to those Buckmeyer said, neither Wade or Holt would even attempt to explain how 2106 furthered the state's interest in promoting decency, the welfare of society, procreation, morality, or any other interest. Judge Buckmeyer's opinion was issued August 17, 1982. He states, Section 2106 does not concern rape, sexual abuse by force, offenses involving minors, or sexual conduct in public, nor does it prohibit sodomy between a husband and wife or between an unmarried male and female. Instead, it condemns only homosexual conduct done in the privacy between consenting adults. Accordingly, it is unconstitutional because it violates both the fundamental right of privacy and the right to equal protection of the laws guaranteed to the plaintiff and other homosexuals by the United States Constitution. While the fundamental right of privacy is not absolute, any regulation of that fundamental right must be justified by a compelling state interest. The judge said, basically, the defendants claim that the state's interests which justify 2106 are morality and decency, public health, welfare and safety, and procreation. The evidence presented at trial did not support any of these claims. Instead, it established that the state had no compelling interest to justify 2106, and that indeed the statute is not even rationally related to any legitimate state interest. As to equal protection, Judge Buckmeyer noted that 2106 discriminates against homosexuals on its face, thus making acts criminal when committed by them but not by heterosexuals. That violates the equal protection of the law unless the discrimination bears some rational relationship to legitimate state purposes. Again, the judge found no such interest. Finally, Judge Buckmeyer rejected that widespread public distaste as being a legitimate state interest, either to rationalize equal protection or the privacy interest. As a fallback position, we had argued that 2106 violated the Establishment Clause of the First Amendment. Judge Buckmeyer quickly disposed of that, noting that there was no proof that the private or primary effect of the law was to advance or inhibit religion. If I may, I would like to read two paragraphs at the end of the opinion. Judge Buckmeyer labeled these conclusion. It's so empowering. Homosexuality is an emotional and controversial issue in our society. It causes fear and disgust among many people. This may result in condemnation of this decision, but if so, the critic should at least have a clear understanding that this decision has little impact on the general public. At issue is a statute which is not enforced by criminal prosecutions, and even if it were, the only punishment is a fine of $200 or less. By this statute, 2106 makes criminals out of more than 700,000 individuals in Texas who are homosexuals, although they did not choose to be, and who engage in private sexual conduct with other consenting adults. This is prohibited by the constitutional right of privacy as well as the equal protection of the laws, because if it were not, the state would have the same power to intrude into the private lives and bedrooms of heterosexuals and regulate the intimate sexual relationships of married couples and single males and females. The Buckmeyer opinion is a comprehensive and powerful and well-written document summarizing the state of the law in 1982. It is well worth a read. With news of the issuance of the opinion on August 7th of 82, Cedar Springs was closed off so that hundreds could celebrate with partying and joyous emotions. For several years, Gay Pride in Dallas was celebrated in August to commemorate the ruling. For the period between August 17 and 1982 until August 26 in 1985, we were not criminals. But as you know, that is not the end of the Baker story.
Thanks, Dick. I'm going to see, our clicker does work. All right, so I'm going to get your slide up there now just so we can see it. This is a great slide that Dick put together. As Shelly mentioned, I'm Wesley Phelps. I teach history up at University of North Texas in Denton. I published a book last year called Before Lawrence v. Texas, The Making of a Queer Social Movement, where I try to trace the history of legal challenges to the Texas sodomy law before Lawrence v. Texas in 2003. And just a little plug, if you're interested in that book, we have some available for sale out in the lobby. And I also wanted to say just what an honor it is to be up here on this stage with Dick Peeples. This is not the first time we've shared a stage together, but I'm honored every time that it's happened. Dick is a real legend in the history that I write about. And early in my research process, when I knew very little about this, and I had come across some legal documents related to Baker v. Wade in the archive down in Austin at the Briscoe Center at UT Austin, kind of got me interested in this topic. I kept coming across the name Dick Peeples in those materials, and so I Googled him and eventually found him. I think I found you on Facebook, maybe. I can't remember how we connected, but I found him, and Dick was so generous with his time. I remember the first time we met over some sandwiches at Panera Bread, and Dick told me what he knew, what he remembered about this case, and it made me realize some of the things that I'd gotten wrong up to that point, just based on the archival sources, and led me in some really new and exciting directions. And it was really some of Dick's words that reminded me that there were a lot of other cases too, in addition to Baker v. Wade, and so that eventually became this book. So it's great to be up here with you again, Dick. So Dick kind of talked about Baker v. Wade up until Buckmeyer's decision, Judge Buckmeyer's decision in 1982, which, as he suggested, was a very momentous decision overturning the homosexual conduct law in Texas. It was the first time a federal judge overturned a state sodomy law based on a constitutional right, in this case, the constitutional right to privacy and equal protection. So this is a huge moment, and there were massive celebrations down in the Oak Lawn area. In fact, the cover of my book is that night after the decision came down, Don Baker went down and was celebrating, and at some point they lifted him up, and he's kind of has his arms up in victory, and so that's the cover of my book. The question then became, what is the state of Texas going to do? Are they going to appeal this decision? And 1982, there was an election happening, but Jim Maddox eventually became Attorney General, and Jim Maddox decided he was not going to appeal this decision, that he didn't agree with he didn't think that 2106 was constitutionally sound or defensible, and it wasn't in the state's interest to pursue an appeal to try to reinstate it. But that really upset a local district attorney out in West Texas, in the city of Amarillo, a guy named Danny Hill, who was also about to face a re-election campaign and was looking for an issue to run on. And as he describes it, he was in Dallas. I think he was here as part of Mark White's campaign, and he read in the newspaper that Maddox wasn't going to appeal this, and so he took it upon himself to try to appeal the decision. And so he petitioned the Fifth Circuit Court of Appeals in New Orleans to be the representative, to be the class representative. His argument was that since all district attorneys in the state of Texas were in the defendant class, and the Attorney General of Texas was unwilling to represent them in an appeal, that he had a right, in fact, he had a due process constitutional right, he said, to represent the defendant class and argue the case before the Fifth Circuit in New Orleans. And after some legal wrangling, there was a panel of the Fifth Circuit who decided that he did not have that right. And then when the court met during an en banc hearing, the full 16-member court, they decided that actually he did. He did have the right to represent the defendant class. So Danny Hill put together this defense of 2106 that really focused on public health. So this was, again, 1982, going into 1983. Americans are learning about the AIDS crisis at this point, and Danny Hill got some other activists together. They were known as this organization known as the Dallas Doctors Against AIDS, which is very misleading because, one, they were not doctors. They were mostly lawyers, a couple of dentists. And two, they really weren't against AIDS. They were against queer people. And so they amassed some quote-unquote scientific information about HIV/AIDS. It was still quite unknown. There were a lot of unknowns about HIV/AIDS in 82 and 83. But their argument was that gay men seem to be most susceptible to acquiring HIV/AIDS, and they are the ones, and then of course bisexual men are responsible for spreading it to the rest of the population. And so a law like 2106 actually protects the public health in Texas because you're prohibiting the very sexual conduct that they saw as spreading HIV/AIDS and making the AIDS crisis worse. So he made that argument in front of the full 16-member appellate court in New Orleans in June 1985. And near the end of August that same year, as Dick mentioned, the court ruled in a very close ruling. This was a 9-7 ruling. They voted to overturn Buckmeyer's decision and reinstate 2106, the homosexual conduct law. And there were a lot of damaging opinions within that ruling. One of them was that gays and lesbians did not constitute a suspect classification. So in other words, to classify people by sexual orientation and then target a law directly at them did not trigger any sort of heightened scrutiny of the law itself, in ways that, say, if you did that by race, if you had a law that only targeted one race, that would trigger this heightened level of scrutiny. The court ruled that sexual orientation is not one of those suspect classifications. So the law itself didn't need to have a compelling state interest to justify it. It only had to be rationally related to a legitimate state interest, which is a lower level of review. And the court ruled, in spite of Danny Hill and Dallas Doctors Against AIDS, in spite of their argument that this was about public health, they ruled that the state of Texas has an interest in promoting morality in society. And if they want to promote morality by prohibiting certain types of sexual conduct, they are free to do that. There was nothing unconstitutional about that. And there's a line I want to share with you from Judge Thomas Reevely's opinion in that decision. He said, "In view of the strong objection to homosexual conduct which has prevailed in Western culture for the past 7 centuries, we cannot say that Section 2106 is totally unrelated to the pursuit of implementing morality, a permissible state goal." So, 3 years after it was struck down, 2106 is back in effect and fully enforceable in the state of Texas. And by the way, Reevely completely misunderstood history in that quote. So at this point, Lambda Legal got involved. There was another case that came out of Georgia around this same time, which you may have heard of, Bowers v. Hardwick. And that case was making its way up through the appellate court system at the same time. Lambda Legal hired the renowned constitutional attorney Lawrence Tribe to kind of chart a way forward in pursuing these cases. There was a very important meeting that happened at the Lambda Legal offices in New York toward the end of 1985 into early 86. In which the decision was made to pursue Bowers v. Hardwick instead of Baker v. Wade. So instead of prioritizing Baker v. Wade and appealing up to the U.S. Supreme Court, it was decided to go with Bowers instead. And I can talk more in the Q&A if you're interested about why that decision was made. But ultimately, Bowers v. Hardwick rested only on privacy. It was just a privacy case because the Georgia sodomy law applied to everyone, not just gays and lesbians. It applied to opposite-sex couples as well. And so the constitutional argument was a little simpler and more straightforward regarding privacy and not equal protection. And so Lambda made that decision to pursue Bowers. Of course, that ended badly. In 86, the Supreme Court ruled in Bowers v. Hardwick that the Georgia sodomy law was constitutional because there is no fundamental constitutional right to engage in sodomy. So they saw the case only about gay sex and not about privacy or anything else. And then, of course, the Supreme Court declined to hear Don Baker's appeal because of their ruling in Bowers v. Hardwick. So after that, the Texas Human Rights Foundation sort of started thinking about how to chart a way forward after this loss. So not only the loss in Baker v. Wade at the Fifth Circuit, but also the tremendous loss in the U.S. Supreme Court in Bowers v. Hardwick. And THRF activists kind of thought, well, best not launch another federal case, right? Lest we give the Supreme Court an opportunity to come down even more firmly against the rights of gays and lesbians. So they decided to mount a constitutional challenge appealing to the Texas state constitution. And so they identified a group of 5 plaintiffs. So there are a couple of differences between Baker v. Wade and this next case, Morales v. Texas. They decided to diversify their group of plaintiffs. So they recruited 5 plaintiffs. Many of these names might be familiar to you. Linda Morales, who is still around, still very much an activist in the Houston area. Charlotte Taft, who is an activist in New Mexico. She just published a memoir. Pat Kramer, Tom Doyle, and John Thomas. So we have a diversity here. So we have gays and lesbians. We have a woman of color, and Morales was the lead plaintiff in that case. So they filed their case in Texas Civil Court in April 1989. This became known as Morales v. Texas. And their argument was very interesting. One, they argued that the Texas Constitution had more protections for privacy and equal rights than the federal Constitution. So they're trying to persuade the Texas civil court system not to worry about Bowers v. Hardwick. We're not appealing to the federal Constitution. We're appealing to a state constitution that protects us even more. And their argument about equal rights had to do with the Texas State Constitution's Equal Rights Amendment. So you might know some of this history, that the second wave of the American feminist movement had pushed for a federal equal rights amendment in the early 1970s. That ultimately failed, but Texas is one of the states that ratified the Equal Rights Amendment. And not only that, but Texas added an Equal Rights Amendment to its own state constitution when those discussions were happening. And all it said is you can't discriminate against people based on sex. Well, the Morales plaintiffs argued that the homosexual conduct law 2106 violated the Equal Rights Amendment because it discriminated based on sex. In other words, a woman could legally engage in oral or anal sex with a man, but she couldn't with a woman. Right? The exact same sexual activity was illegal if you changed the sex of one of the partners. And so, according to the plaintiffs, that violated the state Equal Rights Amendment. They also made very powerful arguments that 2106 served as a justification for discrimination in all areas of life for gay and lesbian Texans. And I think that's what Dick pointed to really well. It's not really that people were being arrested in their bedrooms for having illegal sex, although eventually they would be. That's how we got to Lawrence v. Texas. But what was really harmful about this law is that it justified rampant discrimination against gay and lesbian Texans. So the Morales plaintiffs made that case very eloquently. Like Baker v. Wade, they met some success. In December 1990, a state district court in Austin ruled in Morales' favor. Judge Paul Davis agreed that 2106 violated state constitutional protections of privacy and equal protection. It violated the Equal Rights Amendment of the Texas State Constitution. He also very powerfully argued that sexual orientation, just like race, was a suspect classification and required heightened judicial scrutiny. So if there was a law that disproportionately affected Texans because of their sexual orientation, that law must undergo a heightened level of judicial scrutiny. So he issued a permanent injunction prohibiting the enforcement of 2106. The state of Texas then appealed that decision up to a civil appellate court, and the Third Court of Appeals agreed with Judge Paul Davis in March 1992 and upheld that overturning 2106. They also affirmed the injunction. So again, 2106 is not enforceable during this time. So the only court left in the state after that appellate court was the Texas Supreme Court. And in front of a standing room only crowd in January 1993, the Morales plaintiffs made their case before the Texas Supreme Court. Later that year, in a 5-4 opinion, Justice John Cornyn, who you may have heard of before, issued his decision. And in his decision, he did not talk about privacy. He did not mention equal protection. He didn't talk about the Equal Rights Amendment. He didn't talk about anything like that. Instead, he ruled that Morales and her co-plaintiffs had filed their case in the wrong court. Right? That according to John Cornyn, you cannot challenge the constitutionality of a criminal law in state civil court. Right? I'm sure everyone in this room is aware that Texas has this dual court system. We have a criminal side and a civil side, and the highest court on the civil side is the Texas Supreme Court. But the highest court on the criminal side is the Texas Court of Criminal Appeals. According to Justice Cornyn, that's the path they should have taken. The problem was, if very few people are being arrested for violating this law, it's difficult to mount a case in criminal court. So the Supreme Court overturned Judge Davis's ruling and reinstated 2106 in January 1994. So there's one more case I want to talk about before we open it up for questions, because around the same time that the Morales case was happening, Micah England moved from Tulsa, Oklahoma to Dallas to pursue a job with the Dallas Police Department. Micah England came from a family of law enforcement officers. It was her lifelong dream to be a police officer. She hadn't really found an opportunity in Tulsa. She was working kind of in a kitchen as a chef at the time, but really just dreamed of becoming a police officer. The Dallas Police Department held a recruiting event in Tulsa, which she attended, and she told them, look, this is my dream. I want to be a police officer, but I'm a lesbian, and I've heard that the Dallas Police Department won't hire people who are gay or lesbian. And the recruiters told her, don't worry about that. We are so desperate for police officers right now. Just come on down, apply for a job. That won't be a problem. So she did. Now, she was a very modest means. She had to take time off of work. She told me she had to use up all of her vacation time to do this, most of her savings, to come down to Dallas and apply for this position. And when she went to the Dallas Police Department to apply for this position, there was a question on the application that said, have you ever engaged in a deviant sex act? She sort of understood that to mean, are you gay? Because, the policy of the Dallas Police Department at the time was we cannot hire openly gay or lesbian officers because they admit they are serial lawbreakers. They are criminals. So she wrote, I'm a lesbian, remembering that this recruiter told her that wouldn't be a problem. Immediately, the screening officer said, there's no way we can pursue you as a candidate for a position because you admitted to being a lesbian. Micah was furious. She walked out of the Dallas Police Department office, went to a payphone. Some of you might remember when we used to have payphones. There also used to be phone books attached to those payphones. She opened up the phone book and just went to the G's to look up gay, and came across the Dallas Gay Alliance, and she just called the number. It just so happened that William Wayburn, the president of the Dallas Gay Alliance at the time, was there and answered the phone, and she was crying, telling him what had happened, and he said, wait right there, I will be there in 2 minutes, and went immediately down there, drove Micah back to the Dallas Gay Alliance's office. He told her about, for years, they had been trying to get the Dallas Police Department to change its policies to be less discriminatory. And would she be willing to use her experience to help them out? And so she agreed. That very night, the Dallas City Council was having a meeting. And William and Micah decided to go to the Dallas City Council meeting to raise this issue. And when they got there, the topic of discussion for the night was human rights in China. So for some reason, the Dallas City Council wanted to weigh in on human rights in China. So the way the City Council meetings worked at the time was you had to speak on the topic of the day. So Micah England signed up to speak on human rights in China. And in the lobby, before she went into the council chambers, she noticed an equal employment opportunity poster. So she took that poster down and carried it in with her. And so when it came her time to speak, she came up to the podium and she said, I know the topic tonight is about human rights in China, but I want to talk about human rights right here in the city of Dallas. And she unfolded this poster and she said, the city of Dallas claims to be an equal employment opportunity employer. But I just went down to the Dallas Police Department, and even though I'm qualified in every way to be a police officer, I was turned down simply because I'm a lesbian. Well, of course, this caught city council members by surprise. They were eager to move her along and get to someone else. So with the help of the Dallas Gay Alliance, and from Lambda Legal, Micah England filed her suit in state court in 1990. She argued that the Dallas Police Department's policy discriminated against her as a lesbian woman, and that 2106, which was the basis of that policy, was unconstitutional. Again, she got a favorable ruling from a district court, but because of a technicality after that decision, the city of Dallas missed a filing deadline. And so the case never went beyond that district court level. Micah thinks that was on purpose. She thinks that the city of Dallas did that on purpose. I didn't find any evidence that that was true, but it's certainly possible that that was true. So what that meant was, even though she got a favorable ruling, it was questionable what kind of jurisdiction that court had. How would this be a statewide ruling? And eventually, a couple of other decisions later indicated that no, it would not be a statewide ruling. So this is still somewhat of a failure in terms of overturning that sodomy law in Texas. If you want to know more about Micah, she has a panel in this museum that you can see. So why is this important? I know our next panel is about Lawrence v. Texas, so I'm not going to talk too much about Lawrence v. Texas, but I just want to mention why I think these cases are connected to Lawrence. When John Lawrence and Tyrone Garner were arrested in Houston in 1998, it's doubtful that either of them knew about Baker v. Wade or Morales v. Texas or England v. City of Dallas or any of the other cases that came before theirs. Nevertheless, their case benefited tremendously from these earlier legal challenges. Since the late 1960s, queer activists had created organizations, raised funds, created legal precedents, and provided the momentum to challenge discriminatory state sodomy laws. So as John Lawrence, Tyrone Garner, and their attorneys pursued their case all the way to the U.S. Supreme Court in 2003, they never had to create a legal strategy out of thin air or scramble to find organizations to support their case. Those elements were well established by then. So the point I'm trying to make in my book and today is that if Lawrence v. Texas was necessary for the gains of the movement for queer equality since 2003, and I think it is, I'm arguing that the activism that I document that helped make Lawrence v. Texas possible is also significant, right? That these cases are also critical to the more recent advances in the movement for queer equality. And of course, it shows the value of grassroots activism today when many of these rights are once again under threat. Thank you.
I was going to say, if
Are
anybody,
you going to moderate? Yeah.
Y'all, does anybody have any questions? And I'm going to kind of walk over to you. Yes, Robert.
Professor Phelps, did you mean to imply there at the end of your speech that you received pushback somehow that Baker is not as important or significant as a Lawrence?
Yep.
So,
Hold on just a second. Was I let him repeat?
Oh, sorry.
okay, sure.
Did you mean to imply there at the end that you've received pushback from some in regard to the idea that Baker is not as important as a Lawrence?
I wouldn't characterize it as pushback, but I do think that there's a significant number of people who think that Lawrence v. Texas just came out of nowhere. And that's really what I'm trying to push back on. So there's a wonderful book about Lawrence v. Texas by Dale Carpenter, who's a law professor here in town at SMU, called Flagrant Conduct. I highly recommend this book if you're interested in the details of Lawrence v. Texas. But the feeling you get from that book is this case just kind of sprung up out of nowhere. And I think that's kind of the conventional wisdom of that case too. So what I'm trying to do is push back against that idea that this just came out of nowhere. There were in fact cases that came decades before Lawrence v. Texas that helped lay the groundwork for that victory. And of course, we're going to hear from Lee Taft and from Mitchell Katine, and they might contradict what I'm saying, right? But I think I've made that case that these cases are important.
So, any other questions? Okay. Why am I not surprised, Robert? Here, well, hold on just a minute.
Professor Phelps, you indicated that Micah England answered question 14 on the application with the clarity that she was a lesbian. Mm-hmm. But I thought I heard her say previously that she answered no originally because the question about have you engaged in deviant sex? And she was deeply in love with the only person she'd ever been intimate with, and it was beautiful and kind and tender and respectful. And therefore, her answer was no. But I trust your scholarship more than my memory. Did she not answer it no first?
So let me first say that I respect Micah tremendously. I love Micah. She's wonderful. I've spoken to her several times. But she has told different versions of that story. So I'm actually not sure. I know eventually what ended up on that question was the answer of, I'm a lesbian. It might not have been the very first time she filled it out, but it did end up there. Yeah.
Any other questions, y'all? Okay. Well, we just truly, truly enjoyed that very, very much. And I might just before you, do either one of you have anything that you want to wrap up with?
Well, usually I think I do. When I've talked about this book recently, certainly within the last year, I hate to end on too pessimistic of a note, but I think we are at a time where we need to be aware of the challenges to the rights of queer Americans. And I think that the Dobbs decision, which overturned Roe v. Wade, is very troubling for the future of queer equality. Because, Lawrence v. Texas is based on the right to privacy. It is not based on equal protection, even though Sandra Day O'Connor, wrote this concurring opinion saying that for her it was about equal protection. The majority opinion is based on privacy. Clarence Thomas and Samuel Alito have made it very clear that they don't think that substantive due process is a real thing, right? So they are, in their concurring opinion in Dobbs, say that these cases that are based on privacy need to be revisited, and Lawrence v. Texas is one of them. If Lawrence v. Texas were ever revisited and overturned, the Attorney General of Texas is ready to begin enforcing 2106 the very next day. 2106 has not been repealed by the legislature. It is still there in the penal code as a giant middle finger to all queer Texans, and he has stated publicly that he's ready to enforce that if Lawrence v. Texas ever were to be overturned by the Supreme Court. I can't imagine the kind of chaos that would reign in Texas law if that were to happen, but I think that's something we need to be ready for, and I think that's something an organization like Lambda probably is thinking about, right? And I think it's good. I think we need to be in that space of being aware of the legal challenges that we're likely to face in the next 5 to 10 years. So I don't mean to end too pessimistically, but I think we've got to be on guard about that.
Yeah. And Dick, do you have anything?
I agree with what he just said. I'm a little bit more optimistic that Lawrence versus Texas would not be overturned because of the impact that would have on millions of married couples and other things. But those guys on the Supreme Court are really quite scary.
So one thing I would say, and let's give everybody a big hand. Thank you all very, very much. The LGBT law section for the State Bar of Texas, and there are several folks here who have been on that council over the years, have repeatedly tried to have the legislature repeal 2106, and of course that's never worked out. So I think you're right.